It's the Brian Lehrer Show on WNYC. Good morning, everyone. The 2-week ceasefire between the U.S. and Iran is the headline. We'll talk about some of the details and what might come next. But for our lead conversation today, we want to focus on what almost happened, which might still happen in Iran 2 weeks from now, and which is still happening right now in Lebanon, the purposeful destruction of civilian infrastructure and the killing of many civilians to achieve a military goal. It's still happening in Lebanon because Israel did not fully sign on to the ceasefire with respect to that front in the war, as I'm seeing it reported. Of course, Iran and its proxies have not been shy about killing civilians either. We have two guests, including a former chief legal advisor for international law at U.S. Central Command. But I want to start with some clips from the 2004 movie, The Fog of War. It was a documentary built around an interview with former U.S. Defense Secretary Robert McNamara. He was an architect of the Vietnam War under Presidents Kennedy and Johnson in the 1960s, but arguably the most striking part of that film was when McNamara spoke about the role of the United States in ending World War II. And spoiler alert, he says we committed war crimes. I'm going to play a few clips. In this first one, 45 seconds, he references General Curtis LeMay, who ordered the dropping of the nuclear bombs on Hiroshima and Nagasaki, but focuses here on what the U.S. did before that in Japan.
Why was it necessary to drop the nuclear bomb if LeMay was burning up Japan? And he went on from Tokyo to firebomb other cities. 58% of Yokohama. Yokohama is roughly the size of Cleveland. 58% of Cleveland destroyed. Tokyo is roughly the size of New York. 51% of New York destroyed. 99% of the equivalent of Chattanooga, which was Toyama. 40% of the equivalent of Los Angeles, which was Nagoya. This was all done before the dropping of the nuclear bomb, which, by the way, was dropped by LeMay's command. Proportionality should be a guideline in war.
Proportionality should be a guideline of war. So did he think the U.S. acted proportionately in what he described regarding Japan?
Killing 50 to 90% of the people of 67 Japanese cities and then bombing them with 2 nuclear bombs is not proportional, in the minds of some people, to the objectives we were trying to achieve.
And so here's Robert McNamara's conclusion, one more 45-second clip.
The U.S.-Japanese War was one of the most brutal wars in all of human history. Kamikaze pilots, suicide, unbelievable. What one can criticize is that the human race prior to that time and today has not really grappled with what are, I'll call it, the rules of war. Was there a rule, Ann, that said you shouldn't bomb, shouldn't kill, shouldn't burn to death 100,000 civilians in a night? LeMay said if we'd lost the war, we'd all have been prosecuted as war criminals. And I think he's right. He, and I'd say I, were behaving as war criminals.
Former U.S. Defense Secretary Robert McNamara, a leader in escalating the Vietnam War, looking back on World War II in the 2004 film The Fog of War. Some context to keep in mind as we discuss what President Trump is still threatening in Iran and what Israel is doing in Lebanon, and also what Iran and its proxies do. My guests for this conversation are former Lieutenant Colonel Rachel VanLandingham, professor of national security law now at Southwestern University in Los Angeles, and she was the chief legal advisor for international law at U.S. Central Command, where she advised on international law issues related to the Iraq and Afghanistan wars. and Eliav Lieblich, professor of international law at Tel-Aviv University and author of books including International Law and Civil Wars and Occupation in International Law. He joins us from Tel Aviv. Both our guests are contributors to the journal Just Security, which focuses on national security, democracy, and the rule of law. Professor Lieblich is on their editorial board. Professor Lieblich, Colonel VanLandingham, thank you very much for some time today. Welcome to WNYC.
Thank you so much for having me.
Likewise.
Colonel VanLandingham, before we get into the present moment, I'm curious for you as a former chief legal advisor for international law at U.S. Central Command. As a matter of history, how much did the U.S. bombing of Japan in World War II, as described by Secretary McNamara in those clips, set the terms of the debate for the Geneva Conventions on protection of civilians during times of war, which came after World War II, or codes of conduct for the Pentagon as a matter of U.S. policy? I know this is a big opening question, but those McNamara clips are chilling. They're about the United States and about what Americans generally consider the last unambiguous righteous war, World War II, contextualized very differently by him there.
Thanks, Brian, and please refer to me as professor. It's been over a decade since I've worn the uniform. You know, it's hard to parse out the impact of the specific, operations that Secretary McNamara was describing there, in particular the, atomic dropping of the atomic bombs in Japan. I think the modern Geneva Conventions, modern being that they were updated in 1949 in direct response to the massive scale of human suffering that was incurred during World War II. So I think it's all of it, right? The entire panoply of the body of international law. And it's not just international law, what the United States is party to and believes is binding on it as part of U.S. law and has been institutionalized and incorporated within, a plethora of U.S. laws and Department of Defense regulations. But these things were all a reaction to the massive suffering. And of course, as after every war, there's the victors claiming, hey, look, we were the good guys here, as you mentioned, with the idea that it was the last righteous war. But the United States did engage in massive infliction of human suffering as well. And it's not like the division of the battlefield between civilians and fighters and military objects and civilian objects was brand new after World War II. No, it did exist during World War II, but it was the fact that that line was hurdled over by both sides, right? The firebombing in Dresden, and of course you have the bombing of London by the Germans, by the Nazis. You have a plethora of examples of how civilians became targets during World War II by both sides. So I wouldn't want to attribute it particular just to what happened in Japan or any particular one operation in Europe. It was the massive total, the millions and millions and millions of civilians that not only suffered, but that actually gave up that died during World War II. And then you had the atomic genie, now the nuclear genie, out of the bottle, and the world leaders said we just can't, we have to actually put restraints on this. And those restraints would be a doubling down, a reinforcement, additional supplemental rules to actually operationalize the idea that civilians are to be protected and civilian infrastructure, civilian property is to be protected during war as much as feasible, right? Because we still have to balance it against military necessity. These laws, the law of war is not a suicide pact. So to answer your broad question with a broad answer, the answer is yes. I mean, the modern international humanitarian law, as many of our allies call it, but the United States calls it the law of war, the law of armed conflicts. It, I think, rightly focuses on the fact that it deals with violence, it deals with war. This isn't very humanitarian. It has humanitarian ends, right, to lessen human suffering during war and stop. That is the goal for the laws of that govern the conduct of warfare, the means and methods of warfare, and provide protections for those caught up in war, such as prisoners of war, right? But at the end of the day, the law of war allows for a massive amount of lawful violence. And so the United States focuses on law of war, law of armed conflict, and recognizes that there are lines that cannot be crossed because we don't want a World War III. We don't want the level of suffering that the world incurred in World War II, and the United States, did participate in as or did contribute to, right? But the understandings today are very much colored by and influenced by, and of course the law is grounded in these renewed appreciation for the need to have restraint during war due to World War II.
Professor Lieblich, any thoughts on that same question before we move toward the present?
Yeah, but I would just add that another very important development post World War II has to deal with the level of the legality of the resort to force. So Professor VanLandingham is, of course, correct to point out that the laws of war or laws of armed conflict developed in response to a lot of the human suffering during the time. But not less important is the fact that only after World War II, we have a very clear prohibition on the resort to aggressive force to begin with, which is another level of analysis.
So now let's talk about today. And Professor VanLandingham, I see you co-authored an article on the Just Security website called When War Crimes Rhetoric Becomes Battlefield Reality. The context, of course, is what all our listeners have been hearing about before the ceasefire agreement last night, President Trump's historically unprecedented post on Sunday that called the Iranian regime effing bastards, that sarcastically and offensively included the words praise Allah, and the threat that Tuesday would be, quote, power plant day and bridge day, all wrapped up in one, each and every one of their electric generating plants, unquote. And here he is on Monday reinforcing the threat.
We have a plan, because of the power of our military, where every bridge in Iran will be decimated by 12 o'clock tomorrow night, where every power plant in Iran will be out of business, burning, exploding, and never to be used again. I mean, complete demolition.
Trump on Monday, and as if all that wasn't enough, he posted on Tuesday that Iran's, quote, whole civilization will die, unquote, if Iran didn't make a deal with him. Professor VanLandingham, would you define that as threatening genocide?
Well, at the minimum, it's threatening the war crime of indiscriminate attack. It's completely repudiating the fundamental premise of the law of war, which is that we're going to divide, and we do divide the battlefield, quote unquote, into combatants, fighters, belligerents, military assets, military objectives, and protected civilians. So at the minimum, it's the threatening of a war crime, and indeed can constitute, as my colleague and I wrote about, a war crime in and of itself, which I can address in a moment. And it sounds like it mirrors the last threat, right? The very last one about destroying an entire civilization. I mean, we go back to the Genocide Convention, which, again, is a result of a direct reaction to the Holocaust of World War that occurred during World War II. And it speaks to genocide as acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group. Well, and then it gives examples. The threat to eliminate an entire civilization is incredibly chilling and does reverberate with the concept behind the atrocity crime of genocide.
Professor Lieblich, does anything about international law preclude even that kind of language, or should we just shake our heads at the words but focus on actions as what really matter?
Well, on two levels, I think that international law has something to say. First of all, the laws of armed conflict themselves prohibit spreading terror among the civilian population, right? So threatening to wipe out an entire civilization or to destroy all of the power plants, which actually results in reverberating effects like, destroying healthcare, sanitary conditions, food stocks, and so on and so forth. So that spreads terror in itself. And in addition, to the extent that we can, and I think it's an open question, but to the extent that we can interpret this as a threat to commit genocide, that in itself is also an international wrongful act. So, of course, focusing on actions is important, but I also think that we should take words seriously because words also legitimate, actions, and words by a commander-in-chief also resonate with the troops on the ground and kind of convey expectations. And this also has to do with a lot of things that we're hearing from Secretary of War Hegseth. Things that leadership says resonate on the field. So I would take them seriously, even if we have a tendency to just kind of see them as tweets that have not been thought out well enough.
Can I jump in there for a second?
Sure.
I can't agree more strongly with my colleague than I do, and that's why I wrote about when war crimes rhetoric becomes a battlefield reality, that
Right.
too many individuals want to excuse or just minimize the commander-in-chief, President Trump, the President of the United States, comments as pure bombast or a bullying, negotiating tactic, when the actual threat to eliminate an entire civilization, as well, and coupled with those previous threats to destroy every power plant and every bridge in the country of Iran of 93 million people, those statements in and of themselves are criminal. They are criminal, and they send a completely different message, the inverse of message to the U.S. service members who are actually fighting. And even if it's purely subconsciously, it can seep into the rigorous processes and determinations and assessments of what the lawful way of lawful fighting, of determining lawful military objectives. Because in each one of the assessments, it is supposed to be individually made, for example, for a lawful target, to identify what is a lawful military objective. There is going to be some subjectivity. And and that subjectivity can be inappropriately colored by, influenced by commander's intent. When you have the commander-in-chief making criminal statements, because as my article noted, as Eliav just accurately noted, you cannot threaten. The law of war prohibits threatening civilian populations, and that includes threats of violence with the intent to sow terror amongst the civilian population. And we can infer that President Trump intends the natural and probable consequences of his words. It's reasonably foreseeable that Iranian civilians will be terrified to hear that their civilization was going to come to an end last night. So we can infer that he intended that. That in and of itself is criminal, and it's the reverberating effects of that rhetoric, of those words, on actual tactical level decisions by service members, all the way from strategic to operational, but really the tactical level. Those reverberating effects cannot be ignored. And we ignore them at our peril.
And you also said such threats could put U.S. service members at physical risk. How so on that? You wrote that in your article.
Sure. You think about, especially with the regime, the Iranian regime, the enemies that the United States and Israel are facing, Iran and its proxies, Hamas, Hezbollah, Houthis, who have shown, zero respect traditionally for the actual law of war, for actual following what the international community tells them, and everyone agrees that they ostensibly are going to follow. They've shown zero respect for that, except for to try to gain some kind of legitimacy, right? The whole lawfare concept. So if Iran, hears this, why not just rain complete destruction and terror on its neighboring Gulf countries? It's already engaged in some indiscriminate attacks, some attacks that do not seem to comport with, at least based on the effects and the intelligence out there, to comport whatsoever with the law of war. Well, why exercise any restraint after hearing that if the United States isn't going to be bound by the law, why would anybody else?
Listeners, some of you are calling and texting already, I see, and we invite your comments or questions on international law and the way the U.S. and Israel and Iran and its proxies are conducting the war, short-term and longer term. Later, we'll get to decoding the terms of the ceasefire. 212-433, WNYC, 212-433-9692. Call or text. Professor VanLandingham, I'm going to stay with you for another question before we bring Professor Lieblich back in from Tel Aviv. But in your Just Security article, you wrote, Iranian power plants and other critical civilian infrastructure are protected from attacks by the laws of war the United States helped craft after World War II. Such an object can lose its protection only if it is used for military purposes by the enemy and its destruction offers a definite military advantage. I guess as we start to talk about the exact targets that President Trump was threatening, how do you or how do the Geneva Conventions define military purposes for things like bridges and railways that might generally be considered civilian?
Sure. So, I mean, the actual language from the law, from what's called Additional Protocol 1, it's a supplemental treaty to the Geneva Conventions. The United States is not a party to it, but it has acknowledged that it believes the vast majority of it constitutes binding, what we call customary international law on the United States. And we've incorporated into things like the Department of Defense Law of War Manual and into operational, targeting processes. And a lawful military objective is one that by its nature, location, use, or purpose, that is its current use or future intended use, provides an effective contribution to military action. It does not have to be direct. It's just effective contribution to military action. And whether the targeting would, under the circumstances, whether we're going to neutralize it or actually destroy it, provide a definite military advantage. Mind you, this is only step one of what I view as a tripartite targeting process for the legality, right? So there's still other steps that have to be taken, but the fundamental step, and the one that President Trump's comments for over the last, several weeks regarding targeting, destroying all bridges and all power plants, the fundamental first step is that you have to discriminate between civilian objects and military objects. You have to first find a lawful military objective. Hence why threatening to attack all of them is threatening to engage in what's the war crime of indiscriminate attacks. That's total warfare, saying we don't view any difference between civilians and military in Iran. We're just going to destroy absolutely everything. And that completely pulls out the rug of underneath our war fighters regarding the honorable way of fighting and the legal way of fighting. So for example, for a power plant to become a lawful military objective, to find an effective contribution to military action, we can take an easy example. If that power plant is providing all of its power to that military, to a nearby military base, right? Or maybe it's then it's obviously right. Then it's providing an effective contribution to military action and providing a definite military advantage. The more difficult scenario, of course, is when it's you, and then in the much more typical situation, indeed, if not all of them, would be if that power plant is providing electricity predominantly to civilian homes, civilian hospitals, civilian way of life in the modern world, and also is providing electricity to a military installation or to a particular weapons manufacturing factory, for example. At that point, then you're saying, okay, even though that's not a direct effect, it's an indirect contribution to military action. Then there would have to be an assessment whether the targeting under the circumstances would provide a definite military advantage. What's the military advantage? Is that base actually even being used anymore, or is that factory that's making missiles? Is it actually making missiles at that period? What about going after that missile production facility instead of going after the power plant that's actually providing power to the civilian population? But I just want to highlight for your listeners that's only step one. But of course, if we go back to bridges traditionally, typically can become legit lawful military objectives because of their location and their use or their intended use. And so we saw that there was a bridge that was targeted and destroyed by the United States military last week, and the United States military there was reporting that that the Iranians were using that bridge to transport missiles over it, right? So for its use, and then if it was we had intelligence, it seemed likely that they were going to intend to continue to use it as a logistical line. I mean, lines of logistics have traditionally have long been a classic military target during war, because you need to cut off the logistical supply to the enemy's war fighting forces. But that doesn't mean every bridge. Right. It's not a speculation of, well, every bridge possibly could someday be used by the Iranian military to bring military provisions over. No, that's completely antithetical to this rigorous analysis. So you have to have intelligence that it's either being used or they intend to use it, not just speculation, or by its very location, right? Maybe there's a particular bridge, whereas it's the only way to get to resupply an entire area, and therefore by its very geographic location, it provides that kind of strategic importance where it makes an effective contribution to military action, or definitely will in the future. So it's very context specific, but that's the first analysis level of the analysis. There still has to be the level of analysis regarding taking all feasible precautions in attack to mitigate the impact of targeting on a particular lawful military objective on the civilian population. And that means considering things like the timing of an attack. Will the attack harm less civilians if it occurs at night versus during the day? Can the United States, for example, if we're looking at electrical infrastructure, use carbon fiber bomb, such as has been employed since at least the first Gulf War, that temporarily disables an electrical grid versus completely destroying it so that it can come back online to serve the civilian population faster, et cetera, et cetera, et cetera. And feasible precautions in attack, if it's feasible, the law says it has to be taken. And this really connects back to and operationalizes the fundamental duty that's in the background of the law of war, but it's the leading, but it's in the background, and that is all military must take constant care to mitigate the impact of its military operations on the civilian population. It's the fundamental respect for the principle of distinction that civilians are to be protected. And yes, they are going to be impacted by war, but we have to take constant care to ensure that it's as less as possible, balanced against military necessity. And then I haven't even gotten into proportionality yet.
And I'm going to bring up proportionality right now, but with Professor Lieblich in Tel Aviv. And listeners, if you're just joining us, my guests are Rachel VanLandingham, Professor of National Security Law at Southwestern University in Los Angeles and former Chief Legal Advisor for International Law at U.S. Central Command, and Eliav Lieblich, Professor of International Law at Tel Aviv University and author of books including International Law and Civil Wars and Occupation in International Law. And Professor Lieblich, now we get to the much broader attacks in Lebanon and Gaza affecting civilians that Israel would say are dual-use targets, maybe much in the way that Professor VanLandingham was just describing. The rationale in Gaza for the massive number of civilian deaths in schools and hospitals among the targets has been that Hamas fighters are embedding there specifically to use the civilians as human shields, while the fighters plot more attacks on Israeli civilians. And with respect to what they're doing in Lebanon now to destroy Hezbollah, here's a clip of journalist William Christou from The Guardian on our show last week from Beirut, describing one way Israel is targeting healthcare workers in southern Lebanon to help with that goal.
What we're seeing in those areas, there's a widespread targeting of medics, including through the use of double tap strikes, which is when they strike somewhere, wait for paramedics to come, and then they strike the area again, hitting the paramedics in the process. And what we saw in the last war, what we saw in Gaza, is that the point of this is to make it increasingly difficult for people to stay in those areas, to clear those areas out so that Israel can fight their war easier. And human rights groups have warned against this, saying that, it amounts to forced displacement.
William Christou from The Guardian. So assuming that description is accurate, Professor Lieblich, are those war crimes?
Yeah, first of all, let me just jump in where Rachel finished because I think it's highly relevant. So the issue of proportionality, right, and that ties into your question about dual use objects. Even if we assume that something is a dual use object, meaning that it is usually a civilian object, but it is being used or having effective contribution to the adversary's military operations, attacking it is still subject to proportionality, meaning that you have to point at a concrete and direct military advantage that is not excessive in relation to the civilian harm. So a lot of the critique against Israel's operations in Gaza was precisely that even if we assume that you could point out that there was a certain Hamas fighter there or a certain military objective otherwise in that area, you just can't really make a credible case that the harm, even if it was incidental, right? And that's kind of a charitable reading, was not excessive in relation to that military advantage. And also to point out, and this also relates to the attacks in Iran that President Trump was threatening, that the advantage that counts is only the concrete and direct military advantage, right? So a political, diplomatic, economic advantage or an advantage in terms of morale, that doesn't count because that only allows you to inflate, the one side of the proportionality equation in a manner that would just allow you to inflict almost unlimited harm. So this is a proportionality. Now, regarding Lebanon, of course, I have nothing to say about, reports of targeting healthcare. That's a layup in terms of law. That's just, unless they are actually fighting, that's prohibited, right? And can amount to a war crime if intentional. But I want to say, something about, the source, the recording discussed displacement. So the laws of armed conflict allow evacuating civilian populations from territory. It also mandates giving an advance warning before an attack, right? But this can only be done for the purpose of sparing the civilian population. You cannot use the language of evacuations when what you really want to do is to apply pressure on the civilian population or the adversary or the enemy's government, right? And what we see in Lebanon is, again, we see this dualism. This also relates to President Trump's tweets, that the political echelon says stuff like, nobody is going to return until Hezbollah is no longer a threat, whatever that means, right? And then you have the military echelon saying, no, this is actually meant to spare civilians. So who are we supposed to believe, right? And I think this highlights a broader trend with these type of populist governments that we're seeing today, both in the US and in Israel and in other places, that there's just, the messaging is just highly problematic.
I want to ask, is this even a contentious debate in Israel? So much of the coverage I see says there is broad support across the political spectrum in Israel for the way they've carried out the war in Gaza and the way they are carrying out the war in Lebanon. And to the question of proportionality, I think the world generally accepts that, of course, October 7th was a war crime. To take that big example, around 1,200 civilians killed at a music festival and elsewhere, as the targets were civilian, plus the civilian hostages who were taken. But we see what the response has been and what your description regarding proportionality has just been. Is there a meaningful debate in Israel about this question?
Yes, there is a meaningful debate, but not nearly, I think, wide enough in the general public. In academia, in courts, when people file petitions. So there is a debate, and there has been criticism of the Gaza campaign, but not, as I said, nearly in a widespread enough manner. And I think a lot of it has to do with the political opposition in Israel that just, leaves the field to of the discourse to what Netanyahu allows, in a sense. So he kind of poses the limits of what is the legitimate debate, and everybody follows through without really criticizing the the premises, the basic premises of these activities or these military operations. So I don't think the debate was nearly as critical enough or widespread enough as it should, but it does exist.
So, given what you've just been saying, so much of U.S. and Israeli policy toward Iran is built around stopping them from getting nuclear weapons because given the nature and behavior of the Iranian regime, they're considered more likely than other countries to actually use them. But then should the world be having the same concern about Israel's presumed nuclear weapons? Because Israel in Gaza and Lebanon has shown its willingness to go to extreme military ends to accomplish what it sees as its rights in self-defense. I get questions from listeners all the time. Why aren't we debating Israel's ability to have nuclear weapons and putting pressure on it not to, considering its record, as we do with Iran?
What I think about by no means we should minimize the harmful and problematic behavior by Iran in recent decades, and I think Israel and others in the world are right to be concerned about the premise of the idea of Iran possessing nuclear weapons. But of course, it raises a legitimate question about the other states in the region. But what I think is important is, if we go back to international law, is that, this worry of future possession of nuclear weapons, which is quite unclear whether it's going to happen or not happen, and then, whether they will be used or not be used, all of this type of speculation is precisely why international law does not allow what we call preventive self-defense, which is resorting to war on the basis of speculation about future behavior. Because that can be, again, as you said, the same logic can be then used against Israel and other states in the world, including the United States and others. So I think there's much wisdom in the way that international law is phrased. I don't think it's perfect, but I think the rule against preventive self-defense makes a lot of sense.
When we
and
continue,
Brian, if I could add
Professor,
something
go ahead.
to that.
Yes.
Thank you. I think Eliav's statement regarding the international law governing the resort to the use of force and that not being speculative is that it places after World War II a premium on war as the last resort, not the first resort, that we're going to try to do everything else first to resolve the dispute short of war because war can be so incredibly awful and it can lead to the destruction of the entire planet, giving nuclear weapons. But I want to go back to how that is linked to the very discussion we're having about how rhetoric becomes reality and how it affects the operationalization of the law of war actually by the war fighters. Because when you start talking about nuclear weapons, and of course Iran, unlike Israel, the United States, Iran has threatened to eliminate Israel, to destroy it completely, and so that puts a sharper point on the fear that they will develop a nuclear weapons capacity, because they've said that they will use it to destroy Israel. That doesn't mean that threat has realized or has become close, and therefore there cannot be preemptive, speculative war. There's not supposed to be. However, that rhetoric, the concern of the existential angst posed by nuclear weapons, that then perverts that very important proportionality rule in the law of war that says, hey, look, even if you have a lawful military objective, even if we know that power plant is contributing effectively to some kind of military action, even if you've considered feasible precautions, at the end of the day, the harm to civilians that will be caused cannot be, quote unquote, excessive compared to the direct and concrete military advantage gained. But if warfighters continue to hear that it's an existential threat, that if you don't do this, your country, your parents, your brothers and sisters, your wives and husbands will no longer exist, then no civilian harm will ever be considered excessive. So you can have a perversion of the very rules that are supposed to be protecting civilians that flow from the rhetoric, harmful criminal rhetoric that overblows the threat, or or here in the United States with President Trump's comments that just reject the fundamental premise of how we fight anyway. And again, as Eliav pointed out, the civilian population is not to be manipulated in order to bring an enemy to the bargaining table. I mean, that's one of the fundamental lessons from World War II. And Brian, I did want to circle back because you did ask me originally, why in my article with the wonderful Margaret Donovan, why in our article we pointed out that this kind of rhetoric, if it becomes reality, can harm service members, outside of just the fact that even though the law of war is not based on reciprocity, we follow it despite what our enemy does, because we don't want to be our enemy and we don't want to act like our enemy, and we believe in the pragmatic effectiveness of following the law of war. But there's also the idea of, well, if that one side's doing it, the other side then gets free range. If there was restraint before it's gone. But our point in our article was that, look, obedience to orders after Nuremberg and including in U.S. military law is not a defense to an unlawful order. And so to engage in indiscriminate attacks is an unlawful order, and it must be disobeyed. And so what I understood what was happening within the U.S. military is that the U.S. military is not saying, yes, sir, we're going to indiscriminately attack every power plant and every bridge in Iran. Instead, what I believe, knowing that our service members rely on their training and on their processes, that they were transforming what possibly was an unlawful order, if the rhetoric actually turned into an order. They were identifying target sets which they could find, yes, it was a lawful multi-objective. Yes, in this discrete example, we can have this bridge would contribute. We know that it's going to contribute to military action. And yes, the harm to civilians will be, is not considered excessive. My concern overall, though, is that and again, our service members would be at risk if they did obey that order to a potential order to indiscriminately attack. But you can see how. But I also think there's grave liability for our service members, in particular for the moral injury that they would occur if, despite finding individual discrete targets being individually meeting the legal parameters, in total, the massive civilian harm that would have ensued, if anything even close to what President Trump was threatening to occurred yesterday. It's very difficult to see how that would not be considered excessive compared to the concrete and direct military advantage, again, which is not political. It's not bringing the party to the negotiating table. It would be very difficult to see how that proportionality test would be met, and how our service members could look themselves in the eye and say, we're the good guys and we fought the right way and the honorable way and the way according to our law and values.
When we continue in a minute, I want to get your takes on the 2-week ceasefire that's now been agreed to. Brian Lehrer on WNYC. Brian Lehrer on WNYC as we continue for another few minutes to talk about the international law, about international law and President Trump's threat to destroy, quote, a whole civilization and bomb all the bridges and power plants, as well as the actions by Israel, and certainly including, as you've been hearing, Iran and its proxies, and also now about the 2-week ceasefire that Iran and the U.S. agreed to. We continue with former Lieutenant Colonel Rachel E. VanLandingham, Professor of National Security Law at Southwestern University in Los Angeles now, and former Chief Legal Advisor for International Law at U.S. Central Command, and Eliav Lieblich, Professor of International Law at Tel-Aviv University and author of books including International Law and Civil Wars and Occupation in International Law, and they both contribute to the website Just Security. Professor VanLandingham has an article there now. Professor Lieblich is on their editorial board. I'm going to read one line from a text from one listener that sums up so much of what we have on the board. Professor Lieblich, you first. Listener writes, please talk about enforcement. Right? Some people are finding the discussion very interesting but very theoretical when the countries on all sides and the proxy groups on all sides, on the Iran side, seem so willing to just violate these standards of international law that you've been parsing the limits of?
Right. So, I mean, that's the traditional weakness of international law. So we don't have, central enforcement bodies that you would think, we like to think we have in functioning states. But first of all, if we look at Israel, the fact is that Prime Minister Benjamin Netanyahu is under an ICC arrest warrant. Whether people agree or not, he can't leave the country basically to most of the world, right? So I wouldn't just kind of completely dismiss hard enforcement. But I think that international law works a bit different than domestic law in that sense. It's more of a process in which when you continuously violate the law or show, disrespect to its premises, you chip in at your legitimacy in a way that at the end of the day might really narrow your ability to operate. So for instance, Israel and Gaza, so we know that because of the global outrage to some of the pictures that we've been seeing and some of the policies, so Israel had a harder time to import weapons. We've seen demonstrations on campuses, in other places, and states, all of these things affect the way they can really manage their affairs. So international law, a lot of its enforcement has to be analyzed on the long run as a social process, as a process of contestation and legitimacy, and not just, as a moment in which somebody's getting arrested and thrown in jail. It's a bit more complex than that.
Professor VanLandingham, same question.
I mean, I agree with my colleague that so much of this is about soft power and the erosion of soft power through the degradation of legitimacy. But I also believe that enforcement, quote unquote, can come through. And again, I mean, Nuremberg, World War II said, look, states can be wrong, but individuals commit crimes. So therefore, there has to be individual criminal accountability for things like war crimes, atrocity crimes, crimes against humanity, and of course, genocide. And we've seen a paucity of such prosecutions, even here in the United States, because of politics, because of the failure to truly understand that a failure to follow the law, the orders of commanders, and it breaks down good order and discipline, and that service members sitting in judgment of each other, who convict each other of a war crime. They're upholding that good order and discipline with the unit, but there's often political pressure of, we're the good guys, they were just in a tough spot. So what I see as a part of enforcement that is eventual, a type of soft kind of accountability, or at least a consequence of violations of the law, would be a strengthening of law itself and a strengthening of training. And case in point, the Department of Defense instituted its Department of Defense Law of War program in direct response to the atrocities U.S. forces committed during Vietnam. We had very little criminal accountability for My Lai and for Sung Tong and their other shameful killing, murders of civilians in Vietnam. I mean, we did have a court-martial of Cali and of Captain Cali and of his superior Medina, but the liability there went, of course, much farther. But what we did see is a renewed commitment to adherence by the United States to the law of war, and not just in rhetoric only. It was operationalized by requiring training at every single level of the law of war, and not training just sitting in a lecture hall listening to some lawyer drone on and give PowerPoint slides, but actually incorporate into training exercises. They might not even hear the phrase law of war, but you'll have legal advisors at the National Training Center, for example, here in California at Fort Irwin, where the Army engages in these massive exercises, reviewing how these exercises, these mock battles, are actually being conducted, seeing the requirements for the law of war incorporated into things like a targeting, a methodology, et cetera, and requiring lawyers at every single level. But we don't see, for example, the United States, engaged in war crimes, engaged in perpetrated torture and cruel and inhuman and degrading treatment over the global, the quote unquote global war on terror. There was vanishingly few instances of criminal actual accountability for that. But what did we see in response? We saw new law, Detainee Treatment Act. We saw new law, for example, requiring that at the time the field manual regarding interrogation that was rewritten after Abu Ghraib, it becoming mandated by law for all federal officials, not just the United States military. So we saw actual mechanisms and processes put into place that better aligned with our obligations of the law of war versus individual criminal accountability. We have seen individual criminal accountability for war crimes, and unfortunately, this administration, during its first Trump 1.0, went out of its way to actually pardon individuals that were convicted by their military peers of what constituted war crimes.
So I think what you're saying is it's a constant struggle, a push and pull between the enforcement of or training around international law in war and the propensity by many, including some in the United States chain of command, to break international law, but don't just throw up your hands and say, well, people break it, so what's the point? Keep coming back with training, with laws, and it's never going to be perfect, but you got to keep at it. Is that fair?
That's completely fair. Don't just throw up your hands and say, oh, well, there's no accountability, there's no enforcement, so this just doesn't matter. No, it absolutely does matter. And that really goes back to and helping ensure folks understand with the importance of following these rules. And it's about keeping the moral compass pointed on true north for our service members, in addition to just the pragmatic, benefits on the battlefield, but it's also about how we fight, who we are as a nation.
Before you both go, I want to get at least a brief take on the ceasefire announcement itself. Here is Defense Secretary or War Secretary Hegseth this morning after the announcement, sounding as if the war is over and the United States won. Listen.
Operation Epic Fury was a historic and overwhelming victory on the battlefield. A capital V military victory. By any measure, Epic Fury decimated Iran's military and rendered it combat ineffective for years to come.
Professor VanLandingham, I'll stay with you first. Your take on that? He put all of that in the past tense. Did either side win or lose in this ceasefire as you see it?
Well, 6 weeks ago, the Strait of Hormuz was open to shipping, and I don't even see it open to shipping this morning. So I think it's premature to declare victory.
Isn't that part of the agreement, though, that it will be open to shipping?
Well, I'd like to see it open to shipping, and I'd also like to know what's going to happen with the enriched uranium that still remains in Isfahan, and I'd like to know. And I mean, I disagree with Secretary. It's actually Defense Hegseth, according to the law. The law says Defense Department. When
do you not like the change that they want to Secretary of War? Does that, because some people say to me, look, that signals that we're an aggressor and intend to be rather than a defender. Some people say drop the euphemism Secretary of Defense or Department of Defense and just call it what it is, Department of War.
Well, I mean, I go back to what happened after World War II, in which the United States helped lead the world in crafting the United Nations Charter and said, look, war is a last resort, not first resort. And so putting the emphasis on war as first, I think undermines that fundamental commitment that we view war as a last resort, because war involves massive human suffering. Over 1,500 Iranian civilians were killed in this war. Yes, the United States military behaved incredibly, professionally. It seems like for the most part, very, very honorably. And they should. The United States spends more money on its military than the next 9 countries combined, and the massive portion of our gross domestic product. They better damn well be able to put bombs on target. Right? I'm very proud of them for doing so. It involves immense sacrifice and training, but that we better get what we're paying for by the American people. But just because you achieve tactical operational victory doesn't mean you've achieved overall strategic victory. I mean, we saw that in Vietnam, right? And so I would like to see, I'd like to have more hope that the end game here, that the Iranian regime. I mean, I would love to see the Iranian people living under, in a democracy in which they're not killed by their own fanatical leaders. But that obviously regime change really seems to never quite work when it's pushed by the United States and other countries. But I would like to see some more of these strategic objectives that were outlined actually come through to fruition. And it does seem for me, honestly, today that the United States and the world is less safe today than it was 6 weeks ago.
Professor Lieblich, good compromise for 2 weeks, capitulation by one side or another, even if they don't say that, or how would you describe this?
Well, I agree that there are a lot of tactical achievements, so to speak. So it could be a tactical win in terms of attacking, destroying Iranian military assets and military leadership and so on and so forth. But strategically, I'm looking at this ceasefire and I'm seeing a blunder. You see Iran emerging more confident. It's actually seeking not to return to the status quo ante, but to actually be in a better position than before the war. For instance, it wants to take control over the Strait of Hormuz, which is actually a completely unlawful demand. It has no basis in international law to make this demand, and actually to demand protection money from vessels that are transiting. That should be an open strait. And regardless of legality, the fact that they're in a position to make these demands as condition to maintain a ceasefire means that they're confident that they have not lost strategically. So, and I think we have to not lose sight on that when we're assessing the situation.
Professor Lieblich, Professor VanLandingham, history does not end today, obviously. Thank you very much for talking about the past and the present.
Thanks for inviting us.
Thanks so much.
Brian Lehrer on WNYC. More in a minute.